Thank you all for joining us for ensuring meaningful parent participation, your rights, and school district's obligations on Wednesday, the 18th at 6:30 with Tanya Alvarado. Our disclaimer: the ARC of Lehigh, Northampton Advocacy Department does not employ lawyers nor provide legal advice. This training or any others provided by the ARC's Advocacy Department does not constitute or imply the endorsement, recommendation, or favoring of the providing party or any employees or contractors acting on its behalf. This webinar is being provided for educational and informative purposes only. Thank you for that. And with that, I would like to introduce Tanya. So Tanya Alvarado, she's the founder of Alvarado Law, which dedicates her practice to obtaining appropriate special education services and reasonable accommodations for entrancing, licensing, and certification examining for students and persons with disabilities, including Spanish-speaking families. She has secured appropriate special education services, placement in the least restricted environment, independent educational evaluations, compensatory education, and tuition reimbursement, among other remedies in administrative procedures and federal court. She was born in Ecuador and is an attorney who is both cultural Latina and fluent in Spanish. She successfully represents hundreds of children with disabilities for around 30 years. I don't want to age you so far, so I do apologize for that if that kind of aged you real there. But thank you for your time this evening, and the Zoom is yours.
Well, thank you, Cody, and thank you to the ARC for inviting me tonight. This is a topic I'm really excited about because it provides a family a good roadmap in terms of understanding what your rights are to meaningful participation and what that means in this process. Meaningful participation in the IEP process. Generally, what does that mean? And how much participation is necessary, or is the district obligated to provide the parent so that the parent can meaningfully participate in the program? There's been a lot of litigation in this area, both at the administrative process, due process hearings, and in federal court, regarding how much participation is meaningful. What is the district required to provide? Like, what are their obligations under the law to ensure the parents can understand and participate in the process? And as we go through the webinar, I am going to review the law and what the statutory obligations are, but I'll also provide parent tips to ensure that you're able to participate in the process and understand what your child's needs are and what type of programming is being offered to your child. So some of the comments that I have heard from clients that I participated in the past is, some difficulties with meaningful participation. They can take a lot of different forms. Some parents are only given 1 day's notice regarding an IEP meeting, and they were not able to prepare. Some individuals at the IEP meeting did not know what was in their child's IEP. I've had Spanish-speaking parents indicate that the interpreter did not interpret everything that was said at the meeting. Other comments that, the parent did not understand the evaluation or the progress monitoring that was being conducted regarding their child. And some parents have been given a NORAP to sign before they receive the IEP. And therefore, they had to make decisions about whether or not to agree to a program before they actually knew what the program, was being offered. Under federal law, the United States Supreme Court has decided that parent participation is the core of the IDEA process, that the IDEA process is required to involve a cooperative process between the parents and the school district. And the Supreme Court was very emphatic about the fact that the parent should be an active participant who is able to participate in the process. And we'll break down what that means in terms of the statute very soon. There are other cases that were decided by the United States Supreme Court. The parents play a significant role in the IEP process, and that the IEP must be drafted in compliance with a detailed set of procedures that emphasize collaboration. The educators are required careful considerations of the child's individual circumstances. So the IDEA and the Supreme Court have emphasized the importance of the parent's role in the IEP process. So meaningful participation in this process is broken down by the IDEA in terms of obligations that the school district has. So one of the questions is, is a lack of meaningful participation a procedural violation, or is it a substantive violation? And that's where the balancing act begins. That's where a lot of cases that have been decided by due process and in federal court have tried to strike that balance. How much participation is required for the parent, and when does this procedural violation create a lack of a substantive right? So a denial of a FAPE may be found if there are certain procedural violations that have occurred. So if the procedural violations impeded the child's right to a free, appropriate public education, meaningful parental participation would come in, in that section, because if the parent is not provided meaningful participation, it could very well lead to impeding the child from accessing a free, appropriate public education. One good example is when the parent indicates that there is a diagnosis of a certain need for a child, but the school district doesn't consider that evaluation or really take it into consideration when they're devising the program. If the procedural violation significantly impeded the parent's opportunity to participate in the decision-making process, that's another area where, that hits the parental participation directly. And, or if the violation caused a deprivation of an educational benefit. So there are various areas in the IDEA where, even though a parental right might be phrased as a procedural violation, or a lack of providing the parent that right, when those violations is such that they create substantive violations, that is considered a denial of FAPE. So this slide shows the entire IEP process, and I like this slide because it breaks down the IEP process, and throughout the presentation we're going to touch upon where during this IEP process the IDEA not only requires meaningful participation, but what can the parent do in order to ensure that they are given access to that level of participation. The entire IEP process, of course, begins with an informed consent. The informed consent, involves providing the parent a permission to evaluate in order for an evaluation to occur. Sometimes the parent is asked to participate in like a pre-IEP meeting, or if the student already has an IEP and the parent is being asked to consent to a re-evaluation, that is also considered part of the a situation where the parent has to be provided meaningful participation. The evaluation and re-evaluation process, consent for services, the participation in an IEP meeting, We're going to touch upon parents of limited English proficiency and how that's impacted parental participation, the prior written notice, NORAP, IEP revisions, access to records, procedural safeguards, and mediation. Every aspect, every little square you find on this slide are areas where the IDEA has spoken with respect to what is expected of the district to provide parent to ensure that the parents have a meaningful participation in the process. So, informed consent. The IDEA indicates that the school must obtain informed consent from the parent, and that the school must make reasonable efforts to obtain this informed consent. So what are we talking about in terms of what is informed consent? Under the statute, the parent must be fully informed of all information relevant to the activities for which consent is being sought in his or her native language. So the parent, what does fully informed mean, and what does all of the information relevant to the activity mean? That's where the case law does come into effect. But the parent cannot just be provided a form and just asked to sign it. If there are any questions, and it's one of the things I emphasize, if the parents don't understand a certain procedure, don't understand why a certain assessment is necessary, or don't understand the services for which informed consent is being sought, please ask questions. The school district is required to explain what they're seeking consent for, so that the parent can understand and agree to carrying out the activity. So I have some pro tips for the parents with respect to informed consent. If you don't understand why consent is being requested for evaluations, for instance, ask for a meeting, or ask to speak to the school psychologist or whoever is sending you the request for informed consent. That could involve speaking to the school psychologist, a speech and language therapist, an occupational therapist. The student's teacher may also be the person who's initiating the informed consent, particularly with evaluations. Reevaluations, same list of people, but with a reevaluation and your child has been identified as needing special education services, you can also ask the special education teacher, as well as the school psychologist. But, if you have any questions at all about why the district wants to conduct a certain assessment, what needs are being investigated, you should be asking questions, and then the school district is required to provide sufficient explanation to give you access to understanding what the school district is assessing and what they propose through the assessment. Any changes to the IEP are also areas where the district seeks informed consent, typically through a NORAP. If there are significant changes in the IEP, any revised IEP, any revisions to the IEP may occur during a meeting. At the meeting, the parents are identified as being an important party, really one of the most important parties at an IEP meeting. So if you have any questions regarding any changes to the IEP, you can ask a special education teacher, the supervisor of special education, any of the therapists your child is, who are providing therapists for your child in school, or any other staff who's working with the child, whose information is pertinent to inclusion of any services in the IEP, as well as any revisions to the IEP. But don't be afraid to ask questions if you really don't understand why changes are taking effect or what the district is offering. Please ask these individuals. The entire school district, the people in the entire IEP team have the same obligation to ensure that the parents can understand what is being offered to their child. Okay. Under the IDEA, the IEP team is defined. And the IDEA indicates that the school district, the LEA, this could also be a charter school, a cyber charter school, must ensure that the IEP team includes the parent of the child. At least one regular education teacher if your child is receiving those any services in a regular education environment, a special education teacher provider, a representative of the public agency, someone who can interpret the instructional implications of the evaluation results. So I could be the school psychologist, speech and language therapists, or occupational therapists. And anyone that the parent wants to invite. Sometimes we do run into situations where the school district is asking the parents to sign a waiver, allowing a member of the IEP team to not attend the meeting, but submit their written input in lieu of their participation at the meeting. As parents, you have the right to request that that person attend the IEP meeting. You're not required to sign the waiver or excuse any IEP team participant if you need to speak to them about, any your child's progress in the educational program that's being provided, any revisions or changes that are being proposed, or importantly, any new testing that the school district has done and how that will be impacting your child's educational program. If you find that there's certain aspects of your child's education that are being changed, but that person will not be at the IEP meeting, you have the right to ask that that person attend the IEP meeting. If the IEP meeting is scheduled at a time where that individual could not attend, you also have the right to ask that the IEP team meeting be rescheduled to a time that the person can attend, or you can have a subsequent meeting with that person in attendance. But it is important as parents for you to know that if you have any questions at all regarding the programming, you can ask that that individual attend. This comes into play, as well in an area where your child is struggling. Even though the teacher is not an obvious member of the IEP team meeting, you can ask that one-on-one aides or any other service providers attend the IEP meeting. In particular, if your child has an FBA or any social skills programming where the implementation or where that child is being supported by a one-to-one aide, and especially if your child's having difficulty in certain school environments that are less structured, like the cafeteria, playground. If there's anything happening in those areas, you can ask that the teachers responsible for supervision in that area attend the meeting, especially if the teacher has some information about what is happening. If your child has received any detentions, disciplinary notices, you can ask that the staff member who referred your child for discipline also attend the IEP meeting so that you can get information about exactly what's happening and how that would impact your child's programming. Sometimes the school district sends the assistant vice principal as opposed to the one-on-one aide or the teacher that referred the student for discipline. And you should be aware that you do have the right to ask that the teacher who referred your child to the discipline attend the IEP meeting so you can find out what is happening and meaningfully participate in addressing the programming and your child's difficulties. Okay, during the evaluation and reevaluation process, there are several areas in the IDEA where the parent's meaningful participation must be secured. One is permission to evaluate consent form. It's very clear in the IDEA. The notice must describe any evaluation procedure proposed. The school district cannot evaluate your child without a parental consent because the district is required to obtain informed consent from the parent. That is an area where the parent is required to be provided meaningful participation, a meaningful understanding of why the school district is seeking consent and the types of assessments they want to perform. Same holds true for evaluations and reevaluations. During these evaluations and reevaluations, part of that process is for the district to review existing data as part of the evaluation. The school district is also required to obtain input from the parents, your child's your child's parent, and to decide what additional data might be necessary to determine your child's needs. And that holds true for evaluations and reevaluations. So, if you receive a parent input form and you have any concerns, please don't hold back from informing the school district what your concerns are. As I said before, if you see any assessments or recommendations for types of assessments and you have questions about that, please contact the school psychologist or the person who sent you the form and tell them that you need those assessments explained. Sometimes I see permissions or consent forms to reevaluate the student that identifies any other assessment that may be necessary. That's not informed consent, and that's not a part of meaningful participation. That's an area where you should ask questions. What does this mean? Is this like just an open-ended, any other evaluation that the school district might determine is necessary? If the school district is the only entity making that determination, then you are not being included in that decision-making process. And you certainly would not know if any other assessments are being conducted. So please, keep an eye out for that and absolutely ask questions about the assessments and ask that the assessments be specifically identified in the consent form. Okay, so I have some pro tips here. Again, with the consent to evaluate, as I said before, you can ask the school psychologist questions, the therapist, teachers, anyone involved in that reevaluation process. You can also ask for a copy of the data reviewed and used to make educational decisions. And that is part of the reevaluation process as well. The school district can conduct a records review instead of direct testing of your child as part of a reevaluation. If they are in fact conducting a records review, or even if they're doing additional evaluations, they do have to review existing data. And that is data that is more than what you receive in terms of progress monitoring. Parents under the IEP are required to receive progress monitoring at least as frequently as you receive report cards. However, the data that the school district is basing that progress monitoring report on is not provided to the parent as part of the progress monitoring. The progress monitoring report is a summary of the data and the progress your child has made to, through the date that you received the report. However, there's a lot of data that the teachers are gathering in terms of your child's performance towards IEP goals. How did they perform on the short-term benchmark assessments? And how is a teacher arriving at the conclusion that your child is either not making progress or is making progress? As a parent, you have a right to obtain that data. So if the district is conducting an evaluation or reevaluation because your child's records indicate that more information is necessary, you can't ask, what records are you basing that decision on? And you have an absolute right for a copy of those records. During the evaluation process, there is an eligibility determination. That's another area where the IDEA is very clear. The parents are required to be part of that decision-making process. So the determination of eligibility is whether your child qualifies for services. And it must be made by a group of qualified professionals and the parent. That is specifically included there in the language of the IDEA. Again, emphasizing that the parent is a very important and very pivotal point of participant in this process. So the qualified group of professionals and the parent make a determination as to the child's eligibility. With specific learning disabilities, again, the IDEA is clear that it must be made by the child's parents and a team of qualified professionals. These are quotes directly from the statute. So the IDEA is clear that parents are supposed to be a meaningful participant in this process at every stage of the IEP process. Again, the determination of eligibility or whether your child has a learning disability. Again, sometimes parents rely on the professionals at the school to make that determination because you're not school psychologists, you're not therapists, you can't evaluate your child for a learning disability or other disabilities under the statute. However, you can ask for information, you can ask questions. If you disagree with the determination of eligibility, or if the district says your child doesn't present with certain needs, you do have the right to have that explained to you and to disagree with that as part of the meaningful participation process. Another aspect where the parent under the IDEA is required to have meaningful participation is consent for IEP services. The IDEA explicitly states that the school district cannot begin IEP services if it's the first time they offer IEP services. They have to obtain parental consent. If the parent does not consent, then the school district is not required to provide IEP services. This is only for the first offer of an IEP. But again, the school district must obtain informed consent. So if there's any reason that the parent is afraid of identifying their child as, a student with special needs, or have any concerns about that and are worried about providing consent for any reason, it is something, again, an area where the school district is required to ensure that the parent understand the impact of the identification and the services that are being provided. So please ask questions, ask for clarification. If you're not sure what's happening or what services are being offered, please talk to someone at the district, ask for a meeting, or ask for this to be explained further. I always tell parents, when you're making these requests, please do it by email. Copy the teacher, the school psychologist, the therapists. If your child has a supervisor, special ed, or case manager at the school, copy them as well to ensure that the individuals that are involved in your child's programming are aware that you have questions and can participate in helping to explain what the programming is and what's being proposed. If the district cannot obtain informed consent from the parents for the initial provision of services, they must make reasonable efforts to obtain that consent. So, simply giving the parents an IEP, kind of putting it in the mail and asking for consent to start services through a NORAP is not enough. If the district doesn't hear from the parents, they have to ensure that they have made a reasonable effort to give the parent a reasonable opportunity to participate. So, what does that look like? Number one, they have to notify the parent with enough time to ensure that the parent can participate in a meeting or a Zoom meeting or a telephone call, whatever it is that the district is proposing. The district is required to schedule meetings at a mutually agreed upon time and place. These tips are taken directly out of some cases, due process cases and federal cases where hearing officers and federal judges have determined that a parent was denied the opportunity to meaningfully participate in their child's program. The notice that provides to the parent where consent is being requested has to indicate the purpose, time, location of a meeting, notify the parent who else is going to attend. This is an invitation to an IEP meeting, right? And notify the parent that the parent can invite persons to the meeting. And if the parent cannot attend, the school district is required to offer either individual or a conference call or do a video conference. So the IDEA does spell out different ways that the district is required to try to obtain meaningful participation from the parent. When can an IEP team meet without the parent? There are very few excuses for this. The IDEA indicates that only after repeated failed attempts, documented repeated failed attempts, can an IEP team meet without the parent. And, the documented attempts have to include a record of when, phone calls were made to the parent to try to inform them that there's an IEP meeting, or a consent form was sent to the parent and there has been no response. The school district is also required to document copies of correspondence sent to the parents, again, asking for their participation, informing them of a meeting, or letting them know that they were seeking consent. The school district also can document visits made to the parent's home or a place of business in order to obtain, the parental consent, or ensure that the parent is aware of IEP meetings. Email, of course, is a good way of communicating with the parents, but the IDEA makes clear that repeated attempts must be documented by the district before the district goes ahead and has an IEP team meeting without the parent. So I have some pro tips here. If you're worried about providing consent for services or on a NORIP changes to the IEP, don't understand the information that is being sent to you, you can ask for meetings. You can also ask to review the records that were relied upon by the district. You can get information about why the school district made its decision, and ask follow-up questions to ensure that you understand what is being said. There have been some cases where a school district's use of technical language that is not easily understood by the general public denies a parent meaningful participation. So if you're at an IEP meeting and technical language is being used, or people are talking about significant discrepancies and percentiles or scores that are in the deficient range, and you don't understand the technical aspect of the meaning of these technical words, you can ask questions to make sure that it's explained to you in language that is easily understood by the general public. Please don't feel intimidated, or try not to. I know sometimes you attend an IEP meeting and there are 10 other people at the table. They're all professionals from whom you can ask questions and ask information, and ask them to share the information. If anyone at the IEP meeting indicates, well, based on the progress, or based on my work with your child, and they tell you what what their input is, you can ask for the information, the raw data on which they're basing their recommendations. In terms of another pro tip is to ensure that the individuals who are part of your child's IEP team has your updated information. Sometimes your cell phone numbers can change. if you move or your address has changed, please provide alternate phones, alternate email addresses to the school district. There, could be a situation where the parent moved and has forgotten to update their address, and the school district can make repeated attempts at sending correspondence to the parent's previous address, and as a parent you don't receive that information. If you have moved or anything has changed with respect to your contact information, please ensure that the school district has it, so that when attempts are being made to contact you, that those attempts could be successful. Please check your phone messages and your email junk folder, since sometimes the messages can get lost in there. I know school districts use Class Dojo or other platform to communicate with parents. Please check those messages as well, because you don't want to miss anything. However, the school district, if they can try to communicate with you through either Class Dojo or email, and they have not been successful, they are required to use other means of trying to contact you, like sending forms home with your child, mailing them to your address, or trying to contact you at home or at work. So during IEP meetings, the IDEA has some very specific guidelines in terms of what meaningful participation means. The IEP team must consider and review the strengths of the child, parental concerns, results of evaluations. I'm not going to read this entire list, but everything on this list are things that appear in your child's IEP. You have the right to review the data on which all of this is based. So if you receive an IEP where they summarize state assessments, you have the right to ask for a copy of these state assessments. I mean, the district has them. They're basing this information on something. Any behavioral communication or other need that your child has, any behavioral concerns that have come up, this is information. If anything is documented, you can ask for a copy of that documentation. So some problems that can occur during the IEP meetings could involve lack of sufficient notice to prepare for the IEP meeting. You're either told about an IEP meeting less than 10 days before the meeting, or sometimes it's a day or two before the meeting. And you don't have time to prepare to review the IEP, look at your progress monitoring information that was sent, home during the report cards with your child's report card. But remember, you can also ask for copies, access to the underlying data on which that information is based. I strongly recommend that parents take a look at that, because it can really give you information about what your child is working on with their teacher while they're in school. And you could see where your child is having some difficulty, where a lack of progress is occurring. I often look at these, the data, and find that, in an annual goal where your child is, has a goal of improving their reading comprehension, sometimes a review of the data shows that your child's progress in reading comprehension is very good when they're asked explicit questions. What color was the gentleman's coat? What was the name of, the little girl's dog? Those are explicit questions that your child, the answers of which your child could find within the text. But your child may get all of the inference questions that require inferencing or predictions wrong when they're doing reading comprehension. So a review of the actual data can show you what kinds of questions your child is getting right, and what kinds of questions your child is continuing to get wrong. And that will also help you kind of refocus the annual goal to perhaps, inferencing and predictions with respect to the reading comprehension, rather than focusing on explicit questions if your child is still struggling in those areas. Other breakdowns that may occur before the IEP meeting is where the parent doesn't have access to the data that's being used. The parent's input or concerns are not meaningfully considered. Again, this is all coming from case law, where courts have decided that the parent was denied meaningful participation. If the district does not include concerns or information from the parent or the parent's providers, there are cases where the school district refused to include that information. The court has found that that was a denial of meaningful participation, for the parent. If the parent is not aware what is being proposed until they attend the IEP meeting, that also can lead to a denial of meaningful participation, particularly, if the IEP meeting runs very quickly. The parent has presented that IEP for the first time at the meeting, and you're only there for an hour, and it's a 75-page report. Under those situations, I think it would be very difficult, for the school district to argue that the parent had meaningful participation in that process, especially if it's the first time that the parent has seen the IEP. Everything is new. The annual goals have been significantly changed, and the IEP meeting time was limited, and those were all ingredients for a recipe of the parent not being provided meaningful participation. With respect to parents who have limited English proficiency, there are cases that have been decided where it was apparent that the parents' concerns were not seriously considered during the IEP meeting or even during the evaluation process, due to the language difference. This can take on many different forms. It could, and there are cases out there where the parent was not provided an interpreter. That's a per se denial of meaningful participation. If the interpreter is not properly trained or not fully interpreting what the parent says, or what the school district is saying to the parent, that can lead to a failure to provide the parents meaningful participation. Receipt of documents that are not in the parent's language, the consent forms, IEPs, procedural safeguards notices. The consent forms and procedural safeguards notices can be per se a denial of meaningful participation. A lack of receipt of the IEP in the parent's native language can lead to a lack of meaningful participation for parents. So in terms of, parental tips on how to prepare for an IEP meeting so that you can meaningfully engage in the process and discuss your child's needs is, again, you can ask to see the data on which decisions are being made, and you can ask anytime during the year. You do not have to wait until you're invited to an IEP meeting. If you have any questions, particularly when you're receiving the progress monitoring, and especially if the progress monitoring says your child is making progress in school and you're not seeing that progress at home, you can ask to see the data on which that progress monitoring report is based, so you can have an idea of what is being monitored, and you can even ask for a meeting with the teacher that's providing those services so that you can understand why the district is reporting progress in school where you're not seeing it at home. With respect to parents' input or concerns, if you're at an IEP meeting where there wasn't enough time to ask questions, you felt that, at the end of the meeting, you still didn't fully understand what was being proposed or what your child's program is going to look like, you can ask, and I always suggest by email, for second IEP meeting, particularly with the individuals who are involved in the areas where you have continuing questions. You could send your parental concerns to the district by email Sometimes the parents voice their parental concerns during the IEP meeting, and sometimes those concerns don't make it into the IEP or don't make it into the IEP in the same way that the parent believed they had phrased it. So send them by email so that the district has that in writing and ask that to be included in the parental concerns. Parents can always invite others to the IEP meeting who can discuss your child's concern and who have information that impacts their abilities and their skills and their educational programming. So parents, please note that if you have a TSS worker or mobile therapist coming to the home that may have some additional information regarding your child's needs, you can invite them to the meeting. You can alert the school district that you're inviting someone to the meeting and that they will be participating. You can alert the person, the provider, an outside therapist or a doctor about the IEP meeting date. If your doctor or the therapist is not able to participate on the date of your IEP meeting, you can ask for a follow-up meeting with the IEP team so that this person's input can be discussed. Okay, so if you have lack of sufficient notice to prepare for the meeting, you can ask for the meeting to be scheduled on a different day, so that you can review the underlying data. If you're a parent with a limited English proficiency, and you're concerned that your concerns were not seriously considered, either due to a lack of interpreter or inappropriate interpretation services, you can ask for another meeting to discuss. You can ask that a qualified interpreter attend the meeting. You can invite other persons to the IEP meeting who can discuss your child's needs. And you can also ask for an IEP facilitator, mediation, or due process if a denial of language access during the IEP meeting is denied. Okay. Placement and LRE is another important area of the IEP process where the IDEA is explicit that the school district, the LEA, charter school, the cyber school, the school district must ensure, and I put that language in quotes because it's directly from the statute. They must ensure that the parents of each child with a disability are members of any group that makes a decision regarding the educational placement of your child. Again, you can ask questions, you can ask the IEP team to discuss a continuum of services and least restrictive services that can be offered to your child before your child is removed to a more restrictive setting. So, again, the pro tip, again, data. I think I have this on every pro tip slide for the family. Please ask for the underlying data on which decisions are being based. If your child is being removed from regular education, that should only occur if the nature of the disability is such that education in a regular education environment with the use of supplementary aids and services cannot be achieved satisfactorily. That's very explicit language. It's very strong language within the statute. The district should not be removing your child from a regular education environment under least restrictive principles without first considering the use of supplementary aids and services before they remove your child to a more restrictive setting. Sometimes more restrictive settings are exactly appropriate for your child's needs, but please bear in mind that is a discussion to have with the school district, in which the school district is required, they must ensure that the parent meaningfully participates in that process. In terms of continuum of services, the IDEA does set out that from the most inclusive, or I guess the least restrictive to the most restrictive, is listed there in the order of increasing restrictiveness. So regular education classes is the least restrictive environment. Special education classes would be, a little bit more restrictive, special schools, more restrictive, instruction in the home, and then instruction in hospitals and institutions. So, that goes from least restrictive to the most restrictive environment. Again, there has to be a really good basis for a school district to suggest a change of placement from regular classes to, for instance, instruction in homes or hospitals or institutions. And if you have any concerns about that, please ask a lot of questions and the basis for their determination, especially if you don't fully understand why that's being recommended. If you disagree with your child's identification or their placement or anything regarding the needs that are being identified, you can ask for an independent educational evaluation. If this district's reevaluation is inappropriate, a school district cannot change a child's placement without conducting a reevaluation unless the parents agree to that change in placement. If there is a change of placement that you disagree with, or services are being taken away from your child's educational programming in the IEP that you disagree with, you can reject the NORAP within 10 days and ask for mediation or due process. That will keep your child's services in place. It can stop the school district from making the changes that they're proposing until mediation or due process is resolved. Okay, the parents are required to have a copy of the IEP. Again, this ensures meaningful participation to the parent. The school must give the parent a copy of the IEP. They must give the parent a copy of the IEP. If you're a parent with limited English proficiency, you're entitled to a copy of the IEP in your native language, unless it's clearly not feasible to do so. And again, this is very strong language by, the legislators and, the IDEA, that parents with limited English proficiency are entitled to a copy of the IEP in their native language, unless it's clearly not feasible to do so. Some school districts have an interpreter read the IEP to the parent or translate it line by line during an IEP meeting. That is not, that's not permissible under the IDEA. The only time that reading of the IEP would be appropriate is if the parent's native language is not a written language, or if it's clearly not feasible to provide the parent with this information in their native language. And there is some case law in terms of, failure to provide IEPs in the parent's native language, or failure to have an interpreter during IEP meetings, including deaf, for parents who are deaf or hard of hearing, can be a denial of meaningful participation in the IEP process. And there is at least one decision that indicates that reading the IEP to the parent line by line in another language does not provide the parent meaningful participation. Okay, the prior written notice or the NORAP must be given to the parents of a child with a disability a reasonable time before there's any change in identification, evaluation, educational placement of the child, or the offer of a free appropriate public education, or if the district is refusing to make these changes. And the IDEA is very explicit in terms of what this notice is supposed to provide. Parents do receive it in a NORAP, and that information, again, it's very explicit language in the IDEA that the parents must be given this notice before any changes occur, and this notice must also be in the parent's native language. A failure to provide the parents the information listed here, provided by the IDEA with respect to the child's programming is considered a violation of the IDEA. It's a substantive violation, and it is a denial of meaningful participation. And this slide again reiterates that, the prior written notice has to be in understandable language. Again, we're looking at a lack of technical language, language that is terms of art within a certain field, like speech and language or occupational therapy, that a parent may not understand, and that is not understandable to the general public. And it has to, if the parents' mode of communication is other than a written language, then again, as I stated before, those are the situations where then the alternate modes of communication can be used, like reading it to the parent. Okay, so again, this slide provides a parent information that a failure to give a NORAP or a procedural safeguards notice or a prior written notice is a per se denial of meaningful participation. A failure to give the parent a consent form is also a denial of meaningful participation. If the NORAP or prior written notice has not been provided to the parent in their native language, again, that's a denial of meaningful participation. You can ask for clarification of anything that's written in the NORAP, but please be mindful that if you want to prevent a change from occurring, you do need to reject the NORAP and ask for mediation or due process within 10 days of the receipt of the NORAP or the prior written notice. You can do that first. Ask questions later. You don't want to miss that 10-day limit. If you do miss that 10-day limit, then the district can go ahead and make the changes. I've listed here some additional provisions that are specific to parents with limited English proficiency. Areas in the IDEA where the IDEA is explicit that the parents must be provided the information in their native language so that they can understand what they're consenting to and what the child's programming would be. With respect to parents with limited English proficiency, failure to give IEPs, evaluation reports, reevaluation reports in their native language can be a denial of meaningful participation, as I said before. Parents with limited English proficiency, in addition to having rights under the IDEA, also have these rights under Title VI and the EEOA, the Equal Education Opportunity Act, where the parents are entitled to vital educational records, that they be translated into the parent's native language. A failure to give rating scales, parent input forms, can be a denial of meaningful participation. The rating scales for assessments for parents who are limited English proficiency, many assessments have rating scales in Spanish. So, the failure of the district to provide you rating scales in your native language, if it's Spanish, that should not be happening if the assessment itself, if the publishers of the assessment can provide those rating scales in your native language. There's some languages that, the publishers have not translated the rating scales into certain languages. In those instances, then, because it's not feasible to do so, the district can engage in obtaining someone to interpret or translate these rating scales for the parent so that the parent can understand what's being asked and provide the parent input. Failure to provide procedural safeguards notice in the parent's native language is also a per se denial of meaningful participation. Access to educational records. The IDEA, again, is very clear that as a parent, you have a right to your child's educational records. You have a right to access them. You have a right to receive a copy of them as well. Sometimes school districts do ask parents to go into the school to review records and ask any questions if they have any questions. If that occurs, please do so and ask that a teacher or whoever's responsible for creating the records that you're reviewing be available so that you can ask questions and that they could explain those records to you. Again, the IDEA is very explicit. The parents must be, this very strong language in the statute, must be afforded an opportunity to inspect and review the educational records. The district must permit the parents to inspect and review the records that are collected, maintained, or used by the school district, charter school, or cyber charter school to make educational decisions. And the school district must comply with a request for a copy of these records or to access the records without unnecessary delay before IEP meetings and for any due process hearing or disciplinary hearing. So, and that's within the statute. So if you get an invitation to an IEP meeting and you want to review the data, you have an absolute right to ask for access to the data. You have a right to ask that the teacher be available so that you can ask questions and you can understand the underlying data. And you have a right to do that before the IEP meeting. And due process or the disciplinary hearing. Your access rights include a response to reasonable requests for explanations, a right to request a copy of the records containing the information if the failure to provide those copies would effectively prevent you from participating meaningfully, and the right to have a representative, your representative, inspect and review the records as well. I always advise parents, if you are requesting to access records, please put all your requests in writing. Make sure you send it to the IEP team, the teacher who is responsible for your child, typically the special education teacher. If there's a special education supervisor in the building or assigned to your child's building, I send the request to the supervisor as well by email. You don't have to wait to receive an invitation to the IEP meeting. If you know your child's annual IEP date, you can ask for access to these records well before the IEP meeting. You can make that request within 45 days of your child's annual IEP meeting. So that's about a month and a half beforehand. Make sure you make that request so that you have plenty of time to be given access to the records or to receive copies if you need that for meaningful participation. If you file for due process, send the request for records on the same day that you file for due process, your due process complaint. The district is required to provide you copies of your child's educational records. You can also ask for copies of your child's educational records before a mediation as well, if those records are pertinent, to the issues that you're discussing at mediation. And even if they're not, you are required to have access to your child's records. You can ask to see the records, as I said, anytime throughout the school year. As I mentioned previously, if you receive progress monitoring data and it's not consistent with what you're seeing at home, please ask to review the records, ask to talk to a teacher so that you can understand what your child is working on in school and why the district feels that they're making progress, even though you're not seeing it at home. The procedural safeguards notice also is an area where the school district is required to provide meaningful participation to the parents. And the procedural safeguards notice is so important because it outlines the parental rights. And this procedural safeguards notice, again, under the statute, is required to be provided to the parent in their native language unless it's clearly not feasible to do so. The Pennsylvania Department of Education has a procedural safeguards notice translated in many different languages. So if you're a parent with limited English proficiency, you should be able to be provided this procedural safeguards notice in your native language. I'm sure a lot of parents have received the procedural safeguards notice. It's about 30 pages long. It's in very small print and front and back on every page. So it's an overwhelming document to receive. One of my suggestions is that please read through it. There are many of your child's rights and your rights as a parent explained in the procedural safeguards notice. You don't have to read it all in one swoop. You can break it up into different sections and different sections that pertain to what is occurring with your child. If you're going into an IEP meeting where the district is reviewing a recent evaluation, review those parts of the procedural safeguards notice that involve evaluations, informed consent, and independent educational evaluations. If you're going into an IEP meeting, there are other aspects of the procedural safeguards notice that describe your rights as a parent during an IEP meeting and with some notice requirements. Attend trainings such as the one delivered by the ARC to educate yourself regarding many different aspects of the IEP process. The ARC has wonderful programs and trainings regarding evaluations, progress monitoring, disciplinary procedures, how to read your child's IEP. No questions are bad questions, and no questions are too simple to ask. Please ask as many questions as you can so that you can understand what your child's needs are and what is being discussed in terms of a provision of a program for your child. If you're working with an advocate, ask your advocate questions. If you're working with an ARC advocate, I know through personal experience that they are highly trained and very knowledgeable about your child's rights. Join parent groups in person or on social media. Please, just attend and gather as much information as you can. As I said, you don't have to do it all at once, but just throughout the year, look out for opportunities to learn more, and of course, contact the school district for any questions that you have. And I think I left some time for questions.
That was amazing, Tanya. Thank you.
Oh, thank you.
Thank you.
Round of applause. No, definitely. Thank you. This was fantastic tips for parents and guardians within this. We really appreciate you putting the time to get this together and present this for us this evening.